So estate planning is not really a topic people wake up in the morning and say, yeah, I want to get my estate plan done today. First of all, be real, who wants to talk about what happens the day they die or if they become disabled? Then nobody really wants to have that conversation. And so people try to avoid it. Or people will do it once and then never think about it again. Those are some very big mistakes. So I'm here to talk today about some of the most common and costly estate planning mistakes that we come across when a family is faced with a loved one who has either passed away or is now disabled. So the first and biggest one that we see is there's no estate plan at all. Now, if a person does not have an estate plan, the law essentially gives them one. And what do I mean by that is, if a person passes away and they've never done a will, then the law essentially says who gets their stuff. And it does so by asking questions, essentially by asking, was a person married? Do they have children? Are they children from separate relationships? If none, then it's looking at parents, siblings. Essentially, the law is trying to find who to give that person's estate to. But it does it by category, meaning if it's going to a spouse and children, then it's by categories and it's in equal percentages, and that's it. And maybe you want something different. Or if there are no spouse or children, then it's looking at parents and siblings and whatnot. And it's not just for who receives the inheritance, but it's also on something like naming the personal representative who's in charge. And so when there's no will, and let's just say there's no spouse, and now it's the person's adult children, well, it doesn't say which one. The law doesn't say, well, it's the oldest child, it's the youngest, it's the one that was closest to the decedent, anything like that. It just does it by category. And so with no estate plan at all, then the children or the family, multiple people could want to take on those roles, and then now there's a fight or there's confusion. Where we see a lot of the biggest disputes start to boil up is when there's no estate plan and now this family member is sick, is in the hospital, can't make decisions for themselves. And now if the person's not married, they have multiple children, and now it's like, well, which child is making the decisions? Is it the one that's been with them, been with the parent all along? Is it the one that lives out of state? The law doesn't say which one. And so not having an estate plan, hugely costly mistake. A similar concept is a person did an estate plan 25 years ago and never updated it. Well, a person did an estate plan 25 years ago. It's almost certain that things in their lives have changed. They may have another house, they may have started a business, closed the business, sold the business. Kids are now adults, they're married, the person has become a grandparent. So if the person has not updated their estate plan, now they haven't accounted for the new people in their lives or people who are no longer in their lives, whether it be by marriage, divorce, death, or birth. Any number of things can change the structure of the family, or even just relationships change. And so updating or failing to update an estate plan can be another costly mistake. Another one that we see all too often is a person that created a trust but never funded the trust. And that's actually one of the most frustrating ones that we've seen is somebody spent time, money, and effort creating a trust. They did it on their own, found a template online, paid for it online, or went to an attorney that doesn't specialize in this area and paid money for it, but then they created this trust, but they didn't fund the trust. And what does that even mean? Well, if I just create a trust, and in my trust it says, well, it's managing this business or this house. Let's use a house as the example. It's managing this house. Well, if I don't actually sign a deed transferring that house into the trust, it's as good as doing nothing. So funding the trust means the process of transferring things into the name of the trust or providing a way for it to be in the trust. If you don't do that, it's as good as having done nothing. Another one that I just touched upon is do-it-yourself estate plans. So there are places you can go online. There's some stores that sell sort of packages where you could just fill out forms and whatnot. These do-it-yourself type packages, in Spanish we say lo barato sale caro, which is the cheap option often comes out extremely expensive. These do-it-yourself packages or just finding forms online are dangerous because maybe you're not aware as to some of the things that you have to do or can't do within an estate plan. Like for example, if you own a home and you have minor children, well, The law says the parents pass away owning a home and the kids are still minors, the house has to go to the kids directly. You can't even use a trust. That would be invalid. So things like that can cause for either an entire estate plan or portions of an estate plan to be deemed invalid, and maybe you just don't know what that is. The will being signed incorrectly could be a reason why a will is held invalid. These things matter. The process of creating the plan with an experienced estate planning attorney is the best way to get it done. Another issue we've seen is not naming beneficiaries on accounts or naming the wrong person. We actually, just a year ago, were helping a family where the decedent accidentally named himself as a beneficiary of an account. And so it's the same as having done nothing. And so that account that should have gone directly to the family without probate or anything like that, he had done everything else. He actually did it himself and had gotten almost everything except this one thing, forced the family to go through a formal probate process. It took about 8 months for something that could have been done. If it had been done, that account would have transferred immediately. No involvement of attorneys or anything, or court would have been done. So these are just some of the estate planning mistakes that we see, and it's unfortunate because it really causes a loss of time, money, and creates a lot of frustration for family members when the process could have been done or could have been much easier for them at a time when necessarily they're grieving. So really what we do for our clients is provide that peace of mind that the day that they have either passed away or have become incapacitated, that their family, loved ones, have that ability to deal with the legal and administrative, sort of the logistics that come up when a person passes away, can be much more smooth and really allows a family to grieve, focus on what's most important, grieving, and focus on the family and making sure that the family can just proceed along and start this new chapter in their lives. So we caution you against the do-it-yourself way of doing estate planning or not doing it at all. We certainly believe that everyone should have an estate plan to protect themselves and their family. So if you would like to start that process, you can call us. You may reach us at 305-359-3888 to schedule a consultation. It is completely confidential, meaning what you tell us stays with us. It's confidential, it's a secret, it's protected by what's called the attorney-client privilege. So you can be open and honest with us about what it is that you want to do or don't want to do, some of the things that you're thinking about, and we can help guide you to make sure that your estate plan is not only unique to you and your family, but that also it is valid under the law and can be smooth for your family the day that you're no longer here.